LLC for St. Thomas Health et al.
Good afternoon, Mr. Bolso.
Good afternoon, Judge Clement. Gino Bolso here for the appellant, Murfreesboro Imaging Partners, LLC. With the court's permission, I'll reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
And it is a pleasure to be before all of you here this afternoon. You know, an arbitrator may not ignore the plain language of a contract. That well-settled principle is the theme of our argument this afternoon, and it's also the reason that this court should vacate the award that came down from this arbitration panel in August of 2024. Now, this case interestingly arises out of a joint venture that was formed in 2011 between and among 3 different parties. We had St. Thomas Health, an entity that I believe is well known to all of you, operates hospitals in Middle Tennessee. Then we had this other entity called NOL LLC, which ran outpatient diagnostic clinics in connection with its affiliate at that time by the name of Advanced Diagnostic Incorporated. And then we had Murfreesboro Imaging Partners, our client, which is an LLC composed of 13 members, all of whom are radiologists. They're all physicians here in Middle Tennessee. And these 3 parties came together in 2011 and formed this company called Middle Tennessee Imaging, MTI, the entity on whose behalf we brought this case derivatively. And they went ahead and put together an operating agreement, which was ultimately amended and restated. And they included in that operating agreement non-competition provisions, because the whole concept behind this joint venture was that these 3 parties were going to operate outpatient diagnostic imaging centers here in Middle Tennessee. You know, Davidson County, Rutherford County, Williamson County, surrounding counties. And they put in their agreement that they were precluded, all of them were precluded from competing with this LLC anywhere in Middle Tennessee, which was defined as the exclusive area in the operating agreement. But they also agreed that where any one of those members or any owner, member, or affiliate of those members wanted to compete, that is, offer outpatient imaging services, x-rays, CAT scans, MRIs, other radiologic procedures, similar to those offered by MTI, that the opportunity must first be brought to MTI for its determination about whether it wanted to pursue it. And if the joint venture wanted to pursue the opportunity that one of these 3 members or its owners, members, or affiliates had, then it had the right to do so. It could decline, in which case the member could then proceed on its own. Well, what happened here was that St. Thomas Health, one of the 3 members, opened outpatient imaging centers outside of the exclusive area, that is, in other parts of the United States, including Indiana, Wisconsin, South Carolina.
Was that St. Thomas or was that other affiliates?
It was affiliates of its sole owner and member, Ascension Health, the nonprofit corporation that's based in St. Louis. And that's where the case really gets interesting, Judge Clement, because the operating agreement, section 14.2.1, specifically says that the non-competition provisions apply to each member and to any owner, member, or affiliate of a member. And here, the facts were undisputed.
Isn't there a special opt-out for St. Thomas of some language?
There's a special definition of the term affiliate as used in 14.2.1. The parties agreed that the term affiliate, as to St. Thomas, only applied to entities that it controlled for purposes of the operating agreement. But the facts were undisputed and are undisputed that St. Thomas Health is a nonprofit corporation that has one owner, and that is Ascension Health. And then Ascension itself has other affiliates that opened these outpatient imaging centers across the country. And so on behalf of Murfreesboro Imaging Partners, we sued St. Thomas Health, Judge Clement, because it was clear that they had violated the non-competition provisions of 14.2.1 because it had an owner, Ascension Health, that was engaged in competition with the LLC outside the exclusive area. Well, St. Thomas sought in the arbitration a dispositive ruling that they were not subject, that Ascension Health was not subject to the non-competition provisions because of this special definition that the court just mentioned. And what's clear, Your Honor, is that the panel ignored the words owner and member in 14.2.1 in granting St. Thomas Health's dispositive motion on the basis that the term affiliate had a more limited meaning as to St. Thomas Health. And that's why we went ahead and moved in the lower court and in the Chancery Court to vacate the ruling, because the language is crystal clear. If you have an owner, a member, or an affiliate that competes with the LLC, you have violated the operating agreement unless you first presented that opportunity to the joint venture. And it's true that Ascension Health is not an affiliate of St. Thomas Health for purposes of Section 14.2.1 because of the way affiliate was defined. But it's equally true that Ascension Health remained the owner of St. Thomas, and so it was still in violation of Section 14.2.1 because the agreement, the plain language of the agreement, says that the non-competition provisions apply to a member's owner, member, or affiliate. So, I mean, the panel was correct insofar as Ascension Health not being an affiliate, but it was wrong, completely wrong. In fact, it rewrote the contract when it didn't find that Ascension, as the owner of St. Thomas, was obligated to comply with the non-competition provisions in Section 14.2.1.
This all goes to the merits of your argument about whether or not the arbitrators here exceeded their authority. I'm really interested in the procedural aspects here and whether or not you could treat these partial awards as final. Now, as you indicated in your briefing, there are instances in the federal system, of course, where an arbitration award doesn't resolve all the issues and they still treat it as final for purposes of seeking to confirm the award. And I think, and correct me if I'm wrong here, I think both sides agree that even though the agreement itself, the arbitration clause, is governed by the FAA, we're really looking to Tennessee state law for the appropriate procedure to seek vacatur or confirmation of the award. What is still going on in the arbitration after these two are partial awards? What's still involved in the arbitrations?
What's going on is that our client, Murfreesboro Imaging Partners, is pursuing derivatively on behalf of MTI claims against NOL.
And so why doesn't the fact that that is still ongoing make these two partial awards non-final and therefore not subject to vacatur at this time? Why don't,
Sure.
I mean, I'm just concerned about treating these types of award as final because it seems like to me it would lead to a piecemeal review of arbitrators' decisions.
That is a legitimate concern, Judge McBrayer, but I think the answer just lies in the plain language of the statute, 29-5-329, because it sets out, and this is a new statute that the General Assembly passed just in 2023, I believe, that we passed it. And it provides the circumstances as to when an appeal of an arbitration award may be taken. And a denial of a motion to confirm is immediately appealable.
Yeah,
A
so-
denial of a motion to vacate is immediately appealable, and obviously, an appeal lies from the final ruling. So the piecemeal nature is actually set up by the General Assembly in the statute, prudent or not.
So that's step two, though. I'm
Okay.
I'm more concerned about step one.
Okay.
is You're dissatisfied with an award. When can you or you're happy with the award. So in an instance like this, could St. Thomas and NOL have gone to court and said, Chancery Court confirmed these partial awards? Would that have been permissible?
Yes, I believe under the statute it would have, especially with regard to St. Thomas Health, because the ruling in August of 2024 ended St. Thomas Health's substantive participation in the arbitration, because we were only pursuing them because of Ascension Health, their owners, their parent companies.
So it's sort of akin to, a 5402 type situation when the arbitrators knocked out one party. So how does the interplay then of 320, where the arbitrators give notice of the award, work something like with 319, which is the pre-award ruling by an arbitrator? I know this is not a pre-award, but those two statutes working together seem to me to suggest that, yes, sometimes you can seek rewards, a review or Chancery Court review of an arbitration award, even if it's not final, but you have to go through this formal step where you get the panel or the arbitrator to say, I'm giving record notice of an award, and therefore now you can go and take this pre-award to the Chancery Court to either confirm or seek vacature. That really didn't happen in this case, and so it worries me that we're, again, doing it seems to me all premature.
Well, my only response, Judge McBrayer, is that when you look at 324, it states explicitly that if you are a party who wants to seek to vacate an arbitration award, you have 90 days from the issuance of the award to do it. And so, as a prudent trial attorney, or in this case, arbitration attorney, we went ahead and filed the motion to vacate.
I see. Okay.
Which then brings us under
Fair enough.
29-5-329. So,
But does a denial of a motion to vacate constitute an award when other issues remain?
I believe it does, because when we look specifically at 324, the statute says that where there's a denial of the motion to vacate, that constitutes a confirmation of the award. In this particular case, both of Chancellor Martin's orders specifically confirmed the awards. But even if she had not, the statute provides that automatically.
But does the statute contemplate that denial of the motion to vacate constitutes everything that the arbitration panel was to decide?
I do not believe it does that, Judge Clement, because I think what Judge McBrayer is saying is very true, that this is in the nature of a 54.02 certification, and those are awkward because sometimes they tend to take a unified case and break it into pieces, which is always problematic for appellate courts, and it's not a desirable condition. But it certainly appears that that's the condition the General Assembly gave us.
Well, and I guess the policy aspect of that bothers me too, because arbitration is supposed to be set up to be a more expedient, although you can certainly debate whether or not that truly is the case. You've had your share of arbitrations and appreciate that they can be just as lengthy, if not longer, than regular litigation. But someone that wants to game the system could start, hitting the Chancery Court each time they get a negative ruling and say, hey, vacate this or confirm this, so my win is set in stone, rather than having to wait till the final award. And that's the I'm struggling with.
And it may be something that might require future attention from the General Assembly in modifying 324, because The way we read the statutes, it certainly appeared to us that we were obligated on behalf of our client to file the motion to vacate within 90 days of the August 2024 ruling, and then the rest just naturally flows from it.
Flaws that, yeah.
All right, thank you, sir.
Thank you.
We'll hear from you further on rebuttal. I understand the appellees have agreed to share the time. Is that correct?
Yes, and to do so equally, Your Honor.
Very good. That'll be fine. Good afternoon.
May it please the court, good afternoon. Tor Ernest on behalf of Appalachia St. Thomas Health. I will address two issues. First, subject matter jurisdiction, and second, the merits of MIP's argument, particularly as to the standard of review that applies here. This appeal should be dismissed for lack of subject matter jurisdiction because the orders below confirmed interlocutory, non-final arbitration panel rulings in an ongoing arbitration. The court may have noted that we filed a motion to apprise this court of the status of the arbitration proceedings below recently. The two decisions below are not final judgments within the meaning of Rule 3A of the Tennessee Rules of
So, and as I want to, I'm sorry to interrupt, counsel, but a consequence then, we would dismiss the appeal, but we would remand with instructions to the Chancery Court then to vacate the confirmation and dismiss that proceeding as well, would we not?
No, I don't think so, Your Honor. I think what the court did below.
Well, isn't that sort of eating your cake and keeping it too, or whatever the phrase is?
No, because the decision as to when to move to vacate rested with the losing party in the arbitration, MIP. They chose to seek a ruling at the time they did. The legal sin we think they committed here is to prematurely file a notice of appeal as to that ruling.
Yeah, but as they point out, the clock is running. So I can certainly understand the desire to make sure, if you've got any question at all whether or not it's potentially confirmable or subject to vacature, you're going to want to do it within 90 days, right?
Well, there's no.
Well, first,
That's
actually,
fine.
before I start that, do
Absolutely.
you agree that the procedure is going to be governed by the Tennessee statute?
Well, we agree that the MIP here is moving under the Tennessee statute. The federal statute doesn't give you this sort of interim, even an argument for this kind of relief.
Okay, well, why wouldn't the Tennessee statute apply? The federal statute doesn't address timing at all, and
We're not
timing's
saying-
not inconsistent.
We don't contend that the Tennessee statute does not apply.
Okay, all right.
But the Tennessee statute does, when it uses the term award in 29.5.329A3, we submit that means a final award, because no other construction makes any sense. This court is instructed to look at common dictionary definitions, authoritative dictionaries, and if you look at Black's, if you look at Webster's, you see award means a final ruling, a final judgment. This is also a uniform act, though. The Tennessee Act, obviously, is the Tennessee Uniform Arbitration Act, and it has a provision in it that says, in construing what this statute means, we are to look to the decisions of other courts that have enacted this statute. 3 other cases, and we're not aware of any other states in the country, 3 states have agreed with us that for purposes of this provision, whether it's appealable or not, it only applies to final awards adjudicating all the issues in the case.
Okay, so, but again, you're jumping to the second level of this, and I'm more concerned about the first level. And as I want to make sure I understand your argument, you're saying is, really, it doesn't matter if this partial award is truly an award under 320 of the statute, where the arbitrators have given notice that, the clock is ticking. You can go straight to Chancery Court if it doesn't satisfy 320. 320 is the statute that deals with this award. An arbitrator shall make an award or make a record of an award. The record must be signed or otherwise authenticated by an arbitrator who concurs with the award.
Right.
And then 320 triggers 324 and 5, the timing.
Right. And we think this all relates back to what Your Honor pointed out as the 319, because 319 is really the part of the award that they want to skip. They want to treat this as a final award for purposes of finality.
Well, you wouldn't even call these pre-awards, would you? This doesn't really fall into the pre-award category, does it? That's something different.
It may be a semantic exercise difference, but it's a pre-award decision in the sense that it doesn't bring finality to the proceeding.
Yeah.
That's what triggers the right to appeal and to become before this court, or actually the trial court as well, but for this court one time and one time only, rather than have these yo-yo appeals. Right now we have 2 awards below, partial awards in the sense that they're not final because there are still other matters proceeding, consolidated here. And we contend that this court, it would be a bad precedent as well for this court to consider, for purposes of this statute, those 2 have been final awards that are subject to.
Yeah, so if we looked at this sort of in the analog of state court litigation, and if a chancellor had affirmed or reversed a non-final judgment, our disposition would be, and it would have appealed to this court, our disposition would be dismiss the appeal with instructions and vacating the Chancery Court's opinion and with instructions to dismiss the appeal to the Chancery Court.
I'm not sure that's the case, Your Honor. I think the point here is that you don't get to this court unless, on a partial award, unless you travel under 319, which bakes in the certification under Rule 54 that you have under litigation. So if we're in judicial litigation, you wouldn't get here unless, in a partial award, still other matters pending, unless the trial court certified that the matter was final for purposes of appeal, and you all agreed to take the appeal.
Yeah, but here the Chancery Court is sort of acting as an initial appellate court. So the example I'm giving is, let's say we have an administrative decision. Someone thinks it's final, but it's not, and so they seek a writ of certiorari to the Chancery Court, and that writ gets granted, and the court reviews it, says not arbitrary or capricious, it comes up to us. If we looked at that administrative order and said, oh wait, it's not final, Chancery Court, I mean, again, the disposition would have been dismiss the appeal with instructions to dismiss the writ because you don't have a final administrative order. The administrative body is not through. And that's exactly, it seems like that's exactly what we have here.
Well, I think the difference is we don't have the MIP contending that if it goes back below, they get another bite at this apple. They took that bite, they lost, they came here. They don't get to keep having bites at this apple on these yo-yo appeals on every time, because there could be, between now and the hearing, there could be another partial award. And this is not unusual in arbitration.
But if we take the position that the decision to deny vacatur is an interlocutory decision by the panel, arbitration panel, then the arbitration panel should have the right to reconsider its own decision if a final award has not been issued.
If it's an yes, I think you meant to say the interlocutory decision by the Chancery Court. Yes. Yes, no, I think that's right. I think the Chancery Court, if it's an interlocutory non-final decision, the Chancery Court has the right always under the rules to, and in fact, that's baked into Rule 3A as well.
But that really goes back to the arbitration panel, though, because if the arbitration panel's decision is not final, then there is no timely petition to confirm the denial of vacatur.
The arbitration panel's decision has been acknowledged to be final in the briefing that was filed by MIP. They said it's final.
Do we have to accept that,
Yeah,
though?
we don't
I
have-
mean,
We don't have to.
don't we make our own determination of whether or not it's final or not? Whether it satisfies 320 as an award?
Oh, I think you do, Your Honor. You have to make that independent decision. But this, all I submit, flies in the face of the principles behind arbitration, which is don't get a do-over. You don't get to come into a court and get a court to say, go back and do it over again, arbitration panel, because the bargain that was struck here is we are not going to resolve any disputes under this agreement in a court. We're going to do it in arbitration. And this court decided this, essentially the same issue, this same panel a year and a half ago in the Heritage Construction case, and you went over the standard of review, which is as long as there was a a construction or an arguable construction, we certainly have a construction by the panel of this provision that they're relying upon. As long as there's an arguable construction, there's nothing for us to do. So there may be a sort of an academic issue. I don't mean to slight it. It's important for purposes of protecting this court's jurisdiction and not generating a wave of reviews of interim awards. But I don't think this...
The three cases that you cited in your brief, the Hawaii case and your subject matter jurisdiction argument, what were the dispositions in those three cases?
Well, they would not have gotten before those courts unless somebody was contending that they were non-final. In Texas, you had a denial of a motion to vacate a panel's class determination award.
And so the appellate court dismissed the appeal.
Yeah, well, they denied the motion to vacate that award. That's right. And then in the Hawaii case, the only question was arbitrability. There wasn't a question about jurisdiction, really. In the Colorado case, the entire case was dismissed, and there was an issue about attorney's fees, which often happens in these cases, and they said that's a collateral issue. We still have a final award. So a final award means a final award is the same thing as under Tennessee law. Just because you have a trailing issue about attorney's fees doesn't mean you don't have finality here. So those are the only other cases that looked at this issue, and it's completely consistent with the purposes of arbitration to say you're only going to come up to a trial court once, much less the Court of Appeals. And I see my time is up.
Well, we hijacked you kind of like we did Mr. Bull, so if you wanted to make another point or two.
Well, I think the point that I would make is that turning from the agreement to arbitrate, you cannot exceed your powers as a panel unless you exceed what's in the arbitration agreement. And here we have a very simple one, unlike all these collective bargaining cases that are relied upon by MIP, where you have incredibly detailed terms in the terms of the arbitration. You can do this, you can't do this. So, for example, the classic example is you awarded $70,000, but your agreement says you can only award up to $70,000. You have a cap. So those are cases where you exceed the powers. Nothing in that regard happened here. We just have this statement that they ignored the plain language, but it's really appeal by soundbite because that decision, which is from the Misco case, ignores the balance of that decision, which is that it says the arbitrator may not ignore the plain language of the contract. It goes on to say the parties having authorized the arbitrator to give meaning to the language of the agreement, the court should not reject an award on the ground the arbitrator misread the contract. So there's no do-over. They agreed to have a very learned, very experienced panel decide issues involving tens of millions of dollars that, by the way, they only submitted about $400,000 for. So this is really an effort to gain a windfall by traveling up the mountain, upstream, which was verboten. Mr. Bolso said, I think he misspoke, when he said that St. Thomas opened other joint ventures. That's the crux of this case. It wasn't St. Thomas. The parties agreed to limit any operation of the ROFR, the right of first refusal, or the non-compete downstream. His argument was, and this only came about after their third pleading when they referred to St. Thomas repeatedly in the papers. They then argued, oh, well, that really means upstream to St. Ascension. So we go to the top of the mountain, then we go to all different watersheds around the country, downstream to other subsidiaries not a party to this agreement. This court, if it reaches the merits, as it did in the Heritage Construction case, can look at the plausibility of all these different reasons why the panel, additional reasons why the panel ruled as it did. And it can make inferences as to why the panel did. So, but that's not what we're here for. This court, setting aside the issue about when it's appropriate to determine a final award, this court does not sit in review to rehear or redetermine matters that the parties contractually agreed to have a different body determine. Thank you.
Thank you, Mr. Ernest. Good afternoon.
Good afternoon, Your Honor. Drew Dorner on behalf of the Appali NOL LLC. I'll pick up where Mr. Ernest left off, reiterate that we believe this court should affirm the Chancery Court's denial of the 2 petitions to vacate the arbitration award. And I want to begin picking up on the point that this is not a case in which the arbitration panel exceeded its powers. It was about 30 years ago in 1996 when in Arnold B. Morgan Keegan, the Tennessee Supreme Court defined exactly what exceeding powers is and what that means. And they said, quote, arbitrators exceed their powers when they go beyond the scope of authority granted by the arbitration agreement. It is an exceedingly rare occurrence that that happens, and only the most egregious awards, according to the Brotherhood of Locomotive Engineers case cited in the briefs, only the most egregious awards are invalidated under that standard. The scope of authority in this case, if we were to look at the arbitration agreement in the record, was to make a determination as to whether there was a breach and then award damages, if appropriate, to the appropriate party. And that is precisely what this arbitration panel did. They decided an issue committed to them, and they decided that they weren't going to award any damages. And we can confirm that the arbitration panel did what it was supposed to do and didn't exceed its powers because we can look at what our friends on the other side are alleging in their briefs, or better yet, not alleging in their brief. They're not claiming that the arbitrators decided an issue that wasn't entrusted to them. They're not claiming that the arbitrators awarded relief that they were barred from awarding, much like the $70,000 versus $7,000 example that my colleague described. They're not alleging that the arbitrators made their decision based on some other contract or their personal leanings or prejudices. They're really just alleging that this contract should have been interpreted differently. You should have looked at the members and owners and affiliates language and construed the contract differently. But arguably construing, and that's the standard here, arguably construing, you don't even have to get it right, is all that it takes for a court to have to confirm an award, and for this court to affirm the judgment of the Chancery Court. There's this sort of false premise, I think, in the appellant's brief that plain language doesn't ever need to be construed. If it's plain, there's no construction to be done. But that's false, and it's false based on their own case law. The Fisher case cited in the appellant's brief, even unambiguous language still has to be interpreted. And when you look at the awards here, that's precisely what the arbitration panel did. Surely the parties here had conflicting interpretations of what the plain language might have meant, and the arbitrators dealt with that. They reasoned through it, gave effect to all the words there, and they came to the conclusion that they did. And it's not appropriate under the FAA or even the TUAA, but the FAA applies here. It's not appropriate for any court to revisit.
But what about the procedure? Does the Tennessee statute apply for the procedure of seeking to review the award?
On the procedural aspect, and I'll defer to St. Thomas, it's their motion on that. Certainly we don't oppose it. But procedurally, yes, I would say the TUAA would apply to govern those matters. Yeah.
Okay, and so where does NOL, though, stand on the subject matter jurisdiction question? I mean, I know you probably don't oppose it, but, do you think the Chancery Court had jurisdiction in the first instance to review these partial awards?
Well, we did make that point in the briefs in the lower court that it would have been premature to deal with the petition to vacate. So that was raised.
So because what's going on in the arbitration right now, you've still got a valid derivative claim that the arbitrators are still looking at, correct?
Unfortunately, yes.
Yeah, so, again, I'm really worried about what we're doing here in terms of looking at these arbitration was supposed to happen outside the court system, and now you're getting court intervention in the middle of it. I completely understand the fear of missing the 90 days. If you don't know for sure if it's something you can seek to review, but, I think we need to set some rule about, okay, this is an award that, and I thought 320 was designed to do this, but now I'm starting to wonder if it does that, because now I'm confused about it.
Frankly, you're hearing both sides argue that motion. I think it's it's a prickly pear for the court to deal with. There's no doubt about it. I think when it all comes down to it, We've sided with St. Thomas. We believe that a dismissal of this appeal and coming back for, should there be an appeal at the end of all.
But I'm assuming you also side with the I can have my cake and eat it too point, that if we just dismiss the appeal and let the Chancery Court confirmation of the partial award stand.
As I mentioned, our first point to the Chancery Court when we opposed the petition to vacate was that this was premature. I think Mr. Ernest's argument on that is, I think he's right, in as much as, that they opted to go to the court, they opted to seek that reversal, and the statute says what it says, that you have to confirm. And so, that they sort of set us up for that. What am I going to say? No. But ultimately, it was our position that it was premature in the Chancery Court, and
So
much
it's almost like conferring subject matter jurisdiction by consent, almost.
well, that I'm not sure that can be done.
Yeah. But that's what it sounds like, because they made the determination that this could potentially be reviewable. They're going to get to say, okay, it is reviewable then.
Yeah, I agree. I understand the court's concern on that. I'm already running low on time, so I'll get to just one point that I wanted to make with respect to the second award here. This relates to the validity of a 2019 amendment to the operating agreement. There was a point made in that in the case that the panel ignored language regarding a disproportionately adverse effect that befell the appellant as a result of this amendment. And the only point that I really wanted to make there is it is true that award does not get into Section 610.1. It doesn't really address that, but nor did the panel need to do that. The case law is very clear that an arbitration panel need not address some or all of the legal arguments or factual arguments before it. And I'll note further that Section 610.1 turns on a factual conclusion. It turns on whether or not there was a disproportionate effect on the appellant. Well, if the panel concluded that there is no disproportionate effect, then they don't even need to consider 610.1 because it simply has no application to the situation whatsoever. And I'll further point out that while the award itself does not mention 610.1, there's a presumption. In fact, it's a well-defined presumption going back to 1960 in the United Steelworkers case that the arbitrators are construing a contract even when the award is ambiguous. In fact, it was the Supreme Court that said, U.S. Supreme Court that said, a mere ambiguity in the opinion accompanying the award, here's the key language, which permits the inference that an arbitrator may have exceeded his authority is not a reason for refusing to enforce the award. In other words, the presumption in the face of a silent award or something where the court could see an inference one way or the other, the presumption is that the arbitrators did their job and construed the contract. I see that I've run out of time, so unless the court has any questions, I will take my seat.
All right, thank you very much.
Thank you, Your Honor.
Mr. Bolso, you have time for rebuttal.
Thank you, Your Honor, and I'll try to make 2 points in the 3 minutes that I have. First, with regard to subject matter jurisdiction, obviously this court derives its subject matter jurisdiction either from the Tennessee Constitution or from statute. I think our cases are clear about that. And whether one might question whether the Chancery Court should or should not have considered the motion to vacate, the fact of the matter is that it did, and it issued a ruling denying the motion to vacate and confirming the award. And once there is such an order, 29-5-329 vests this court with jurisdiction, with subject matter jurisdiction, to entertain the appeal. And whether it was prudent for the statute to be set up that way or not, obviously is a separate question, because I certainly share Judge McBrair's concern about how this breaks up the case in a way that's not ideal. But that, unfortunately, I believe is the way the statute works. And, we had notice in August of 2024 under 320 of an award. It let St. Thomas out of the case completely. And so we were duty bound under Section 324 to file that motion to vacate within 90 days. And the court addressed it and issued a ruling. And once that ruling came down under 324, then I think that vested this court with jurisdiction under 329 if a notice of appeal were timely filed within 30 days. And then the second point is the substantive one. What the panel decided here, I say with respect, was egregious, because it's true under both the Federal Arbitration Act and the Tennessee Uniform Arbitration Act that an award should not be vacated unless the arbitrator exceeds the power that the arbitrator has. In this case, it's a panel. But our cases make clear that an arbitrator exceeds his power where he ignores the plain language of a contract or where he manifestly disregards the law. And that is precisely what happened here. Our contract could not be clearer that it was the owner, member, or an affiliate of a member that was bound by the non-competition provisions. Ascension Health was an owner of St. Thomas, so it was bound by the non-competition provisions, and the panel just ignored that. They just looked to this definition of affiliate as though it were conjunctive, not disjunctive, and decided to dismiss St. Thomas. That was a direct violation of the agreement. Courts, I mean, even courts cannot create a new contract for parties. Even more so, arbitration panels cannot do that. And I think Judge Lewis's decision in that International Talent Group case from 1988 is right on point, because in that case, there was a limitation of liability to the amount of fees earned by the defendant from the sale of the software, which was $7,500. The plaintiff claimed that that remedy failed of its essential purpose and got $76,000. And Chancellor Brandt, when he got the case, he said, no, that arbitrator, you exceeded your power because you violated the contract. And the Court of Appeals affirmed, Chancellor Brandt, that you can't do that. Well, that's exactly what happened here. They took a contract that's crystal clear and they created a new contract. That's why we brought this appeal. From our perspective, the court does have jurisdiction, and we appreciate the court's indulgence. Thank you.
All right, thank you. Thank for all three of you for your arguments. You have given us a lot to think about. We'll try to get a ruling out by Monday. It'll certainly take some time, but we'll give it our very best effort. That concludes the afternoon docket.